Hi, good morning. My name is Robert Maher. I'm an immigration attorney. I want to talk to you a little bit today about what happens if you get into trouble while you're in the United States. The title of the talk is, What If I Get Into Trouble? Occasionally students, visitors, and lawful permanent residents or green card holders in the United States encounter the criminal justice system and contact me either before or after they've worked with a criminal defense attorney. Callers are usually very upset and very concerned about what effect, if any, a potential conviction will have on their current and or future immigration status. People would like to know that if they leave the country, if they'll be able to come back in, or if they're staying in the country, if they're going to be deported. The answer is much depends on the status of the accused, the nature of the crime, and the length of a jail sentence if imposed. In short, however, criminal conviction can have grave consequences in the immigration context. Therefore, if you're arrested, it's very, very important that you have an experienced criminal defense attorney and an experienced immigration attorney review these consequences with you. The two main issues surrounding the non-citizen convicted of a crime or even accused of a crime is whether the conviction is going to make the person inadmissible or deportable. Okay, the Immigration and Nationalization Act, Immigration and Nationality Act, governs and defines the types of crimes that render a person either inadmissible or deportable. Inadmissible means the person is not allowed in the country. Deportable means that the person should and might be removed from the country. Convictions for crimes involving moral turpitude, also known as CIMTs, and aggravated felonies are two types of crimes that can have serious immigration consequences and can render a person either inadmissible and or deportable. Let's look first at crimes involving moral turpitude and their effect on inadmissibility. Okay, that means a person not being allowed in the country. Okay, the Board of Immigration Appeals, the board that hears appeals from trial court judges, has said that a criminal offense involves moral turpitude if the relevant statute, that's the statute that the person's charged under, defines the offense in such a way that it necessarily entails conduct on the part of the offender that is inherently base, vile, or depraved, and contrary to accepted rules of morality and the duties owed between persons or to society in general. Sounds pretty harsh, okay? Unfortunately, however, neither the seriousness of a criminal offense nor the severity of the sentence imposed is determinative of whether a crime involves moral turpitude or not. Okay, so there are some crimes that are not necessarily serious looking on their face, but that may have serious immigration consequences. That's why you have to analyze the nature of the crime, because a conviction for such a crime, or even an attempt to commit such a crime in some cases, can render an alien inadmissible. All right? And there are exceptions to this rule, like there are exceptions to most rules, and that is if the maximum penalty possible for the crime did not exceed imprisonment for 1 year, and the alien was not sentenced to a term of imprisonment in excess of 6 months. That means the person got less than the 6-month sentence. In that case, we call that a petty offense exception. That means it was an offense that was punishable by less than 6 months. Second, there's a situation where if a person is convicted of 2 or more offenses where the aggregate or combined sentences were 5 years or more. Okay? In this case, it doesn't matter whether the offenses were from one crime or the sentence was related to more than one crime. And if these crimes involve moral turpitude, then the person can be rendered inadmissible under these circumstances.